And if y'all can just sign that, and if you'll make sure and email the attachment to the clerk this afternoon.
Yes, ma'am.
Thank you.
Do you call them?
I'm deleted. Let's see, and I'm going. And we're going on the priors, correct?
Yes, sir.
Okay, let me,
Actually, Judge, it was indicted in a state jail with priors. However, I've also filed a notice of enhancement alleging additional offenses that I believe gets it to a second degree. So in other words, it was indicted as a state jail felony enhanced to a third degree, and I filed a notice to enhance that further to a second degree.
all right, I'm printing out something so I can do. Make sure I go through, okay. And will he waive the formal reading of the indictment?
Yes, Your Honor.
Mr. And sir, you're Leroy Smith Jr. And Mr. Smith, in cause number 25 DCCR 0052, you're charged with the state jail felony offense of criminal mischief from September 4th of 2023. The indictment alleges that you were previously convicted of the state jail felony offense of delivery of a controlled substance September 18th of 1995. And after that was final, you were convicted of delivery of a controlled substance, state jail felony, 2 cases on January 16th of 2001. The state has also filed notice of intent to use prior convictions to enhance punishment. It alleges that you were also previously convicted of possession with intent to distribute crack cocaine and/or distribution of more than 5 grams but less than 50 grams of cocaine in the Eastern District of Texas on August 6th of 2002, and that on February 2nd of 1993, you were convicted in 2 cases of burglary of a building, which at that time was a third-degree felony, I believe.
Not sure, Judge.
Anyway, and then after that was final, well, we need to know.
I've got the process, Judge.
And then burglary of a vehicle also on that date. Need to know what those levels
The
are.
burglary of a building, at that time, Judge, was, looking at the judgment from February 2nd of 1993, was a second degree.
Second-degree felony. And so to the charge in the indictment,
For the record, Judge, that
Yes, sir.
burglary of a vehicle was a third degree.
thank you, Mr. Coleman. And so to the charge of criminal mischief, how do you plea? And are all of those prior offenses true? Speak up, please. And are you entering your plea of guilty and true freely and voluntarily? And because you did what they've charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Jackson? Do you fully understand them? And do you understand, so it looks like there's no agreement, is that correct? Or is there a cap?
There is no cap, there is no agreement, Judge.
So it looks like you are just pleading open to the court. These papers show that your attorney is asking on your behalf for a deferred probation. Mr. Coleman has requested an 8-year term in TDC. But if we go forward this way, you're leaving your punishment up to me. And I want to make sure you understand you have an absolute right to have a jury come in and determine 2 things. The first would be to determine if you're guilty or not, and then you could leave your punishment up to that jury. If we go forward this way, you're waiving that right, and is that what you want to do? I do want to make sure you understand that I can do anything in the full range of punishment, which because of those prior offenses is between 2 years and up to 20 years in prison. Do you understand? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1. Mr. Jackson?
No objections.
It's admitted. Is there any evidence that Mr. Smith is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you are mentally competent and you understand the nature and the consequences of this plea, find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. It'll give me more information about you, your cases, and then we'll come back later for sentencing. Anything that you think is important for me to know, be sure and talk to Mr. Jackson about that, and he will present it to me on your behalf when we come back. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right there. All right? We'll see you back at sentencing. Thank you.
Thank you, Judge.
And make sure you get that document emailed over
Yes,
for the
ma'am.
discovery. Mr. Barbo, we called your case earlier and you weren't here.
I'm sorry, John, I was outside, farther down, then I should have gone.
Okay. All right, I'll recall those bond forfeitures.
I was thinking about my outreach.
Well, you need to be close so that when the
My apologies.
bailiff calls your name, you can hear it.
You're right.
Okay, Mr. Barbo, in cause number 24, DCCR 1722, you're charged with the state jail felony offense of theft of property with previous convictions. The indictment alleges that was from April 28th of 2024. It alleges you were previously convicted of theft September 8th of 1999, January 5th of 2000, February 7th of 2000 in 2 different cases, September 27th of 2010, May 4th of 2011. It further alleges that you were convicted of burglary of a vehicle, a third-degree felony, in 2 different cases, May 19th of 1986, and that after that was final, you were convicted of delivery of marijuana, a third-degree felony, in 1987. 2 cases of delivery of marijuana on that same date, and that after all of that was final, you were convicted of possession of a prohibited substance in a correctional facility, a third-degree felony, July 31st of 1996. What that means, sir, is that if you go to trial and you're found guilty in that case, the punishment would be enhanced to that of a second-degree felony, which is between 2 years and up to 20 years in prison. Do you understand?
Yes, ma'am, I do.
Give me just a second. And then in cause number 24, DCCR 2289, you're also charged with theft of property with previous convictions from September 28th of 2024. That indictment alleges all of those same prior offenses, which means if you go to trial and you're found guilty in this case, the range of punishment would also be that of a second-degree felony, which has a punishment range between 2 years and up to 20 years. Do you understand?
What was the last one you just read, John, please? The 2024?
The indictment date on this case is from September 28th of 2024.
What was that? What was that about?
That's why you have a lawyer.
In Your Honor, for the record, the state will be filing a motion to accumulate the sentences in these, or for the sentences in these cases to run consecutively, Judge.
So, in the September 28th of 2024 case, the allegation is that you unlawfully appropriated property, to wit, medicine and sundries of the value of less than $2,500 from John Almaguer, which is
That's from
the Walmart on Dallin Road, from, again, September 28th of 2024. So you're charged in 2 different cases from 2 different dates with theft of property. One from April 28th of 2024, the other from September 28th of 2024. Again, what that means in each of those cases is if you're found guilty and those prior offenses are true, the ranges of punishment are between 2 years and up to 20 years. Do you understand?
Yes, ma'am.
And I have here on the computer a plea bargain rejection that has your signature on it in each of these cases with that of Mr. Kimmler's that shows that the district attorney's office has made an offer, if you wanted to enter a plea of guilty, for a 5-year term in prison on each of these cases that would run concurrently, which means together at the same time. I also want to make sure you understand what Mr. Coleman just said, and if you go to trial, because these are different offense dates, there is the possibility, if you're found guilty in each case, that he could ask me to stack or accumulate, run consecutively any sentences that you receive, and that would be up to me. Do you understand all of that?
Yes, ma'am, I do.
And do you want to reject those offers and have both of your cases set for trial?
Yes, ma'am, I do.
Okay, I will get them set on the trial docket. Mr. Coleman, is there any reason to believe there would be any change in that offer?
Absolutely not.
So I want to also make sure you understand that after today, I will not accept a plea offer in these cases unless there is some new information that comes to light that for some reason the attorneys don't know. And so if you change your mind later and want to enter a plea of guilty, it would be to something different than this plea agreement or just open to the court. Do you understand?
Yes, ma'am.
All right, and you want to go forward with trial?
Yes, ma'am.
Okay, I'll get your cases set on the trial docket. Stay in touch with Mr. Kimmler. He'll let you know when you need to be back. Mr. Savoy, you're charged in that case with the third-degree felony offense of tampering or fabricating with physical evidence with the intent to impair from September 23rd of 2023. And how do you plead to that charge?
Plead guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Ms. Holmes?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've reached is for a 4-year deferred adjudicated probation. There would be a $300 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes, ma'am.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is
Your
there any
Honor, excuse me, I apologize. One of those is forfeit the weapon as well as part of the plea agreement.
I don't think y'all wrote that on here, but.
Yeah, but that's fine.
And is it your understanding that also as part of that plea agreement, the weapon in that case will be forfeited to the state? Do you understand? So you won't get the gun back. Do you understand that? Okay. And if y'all just make sure, I don't know if you need a forfeiture motion, and I'll sign that order at
I'll
sentencing.
go grab it from Mr. Mayor Court.
Okay. Is there any evidence that Mr. Savoy is not competent?
No, Your Honor.
Okay. I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your cases for sentencing at a different date, and we'll get the probation department to do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back later for sentencing. All right, sir, again, you're Donald Owens Jr.
Yes, ma'am.
And so the motion to compel, has that been worked out?
Yes, Judge.
All right, you have all the information, discovery, that you feel like is out there, correct?
Yes.
Do you need me to sign that order, or it sounds like it's been taken care of? So, Mr. Owens, in cause number 24, DCCR 1192, you're charged with a second-degree felony offense of sexual assault of a child from March 29th of 2024. And what that means is if you go to trial and you're found guilty, the range of punishment is between 2 years and up to 20 years in prison. Do you understand?
Yes, ma'am.
And I have here on the computer a plea bargain rejection that has your signature on it with that of Mr. Kelly's. This shows that the district attorney's office has made an offer, if you wanted to enter a plea of guilty, for a cap of 10 years in prison, which means you would be leaving your punishment up to me, and if I followed the agreement, I couldn't give you more than 10 10 years. I could give you 10 years, I could give you less. It would all depend on the information that was brought to me at a sentencing hearing. You have every right to reject that offer and have your case set for trial. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are. And do you understand all of that?
Yes, ma'am.
And do you want to reject that offer and have your case set for trial?
Yes, ma'am.
Okay, and everything's done, discovery, no, nothing, not waiting on DNA or anything like that? Okay, we'll get it set,
Everything we've asked for.
get it set on the trial docket, stay in touch with Mr. Kelly, he'll let you know when you need to be back and ready for trial. All right, thank you.
Judge.
Okay, good morning, sir, are you Corey Carter?
No.
And will your client waive the formal reading of the... Mr. Carter, in cause number 24, DCCR 2204, you're charged with the third-degree felony offense of deadly conduct discharging a firearm from October 13th of 2024. And how do you plead to that charge?
Guilty.
Say it, I'm sorry. Are you pleading guilty freely and voluntarily?
No.
And are you pleading guilty because you did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Kimmler?
Yes, no.
Do you fully understand them?
Yes, no.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, no.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
Without objection.
It's admitted. Any evidence that Mr. Carter is not competent?
I'm not aware of any of those.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of that plea, find sufficient evidence to find you guilty, and at this time find you guilty of deadly conduct discharging a firearm, sentence you in accordance with your agreement to a term of 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification. That shows that this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment that I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Kimmler. All right? Good luck to you, sir. Thank you, Mr. Kimmler. Thank you,
Your
Mr.
Honor.
Nichols, for getting that taken care of early. Good morning, sir. You're Paul Westbrooks?
Yes, ma'am.
And Mr. Westbrook's cases are set for trial to begin with jury selection next Monday. What is the announcement?
State's ready, Judge. We're ready, Your Honor.
Okay.
We have made a new offer, Ms. Westbrooks has rejected that offer.
Okay.
Put that on the record, just.
Sure. So I want to make sure you've relayed the offer. I know yesterday you were here and given some time to think about what that offer was. It's my understanding it was a reduction to manslaughter for a 20-year term in prison. You have every right to reject that. Your case is set number 1 for trial next week. We'll get it tried. Just want to make sure you understand. And you do, I think. You've gone over it with Mr. Vasquez. We've already been through trial, so you understand what the possible consequences are if you're found guilty at trial, correct?
Yes, ma'am.
And you want to go forward next week with trial, correct? All right, and are we going like we did last? What's the state's position on trying both cases or
We're
one
not
case?
trying them together, Judge. We're going to try the murder 0329,
Okay,
23 DCCR 0329
okay,
separately.
okay, so we will get, so for next week, it's the 0329, which is the straight murder, not capital murder.
Correct.
Okay? So we will get that started Monday, pick jury selection at 1 o'clock.
If I may, Your Honor. Mr. Westbrook, you understand the state's offer. What the state has offered is the capital murder would be dismissed, and the, what's called a regular murder would be, you would be pleading to the lesser included manslaughter for a term of 20 years. And you wish to turn that down,
Yes, sir.
and you want to move forward to trial.
Yes, sir.
And we're starting the regular murder Monday?
Yes.
Thank you, Your Honor.
Okay, there'll be no negotiations, no pleas after today. We'll get started with jury selection on Monday, okay? You can go back with the bailiff. Thank y'all. Okay, and Mr. Bowden's cases were reset from last week because you were going to be over in Chambers
I went to
County.
Chambers County, I spoke to them, they said they would pull the file and send me an offer. I called them the next day, they still hadn't done it, I've sent like 7 emails, I've made multiple calls, including again this morning.
Okay, so this
And
is either
they're-
going to be a plea or a trial then over here.
And I know at this point, I guess we're gonna have to set it for trial, like, because if I plea them, Your Honor, that opens them up to automatic revocation over there and much longer than these sentences could be here.
Your Honor,
So-
the state's offered, if I may, I'm sorry.
Yeah.
Yes, please.
Of the minimum of 2 years in both cases will be withdrawn if not accepted today. I previously told you.
Yes, we talked about that, but-
And in addition to withdrawing the minimum offer of 2 years to run concurrent on both cases, the state will seek or file a motion to accumulate these 2 cases, meaning stack sentences on top of each other.
I understand, Your Honor, but still, if I let them plead to this, it would automatically,
I mean, that's fine. So I want to make sure y'all go talk to him about what Mr. Coleman just said.
if you give me a second, I'll tell him that and let him make the decision.
Okay.
I know what I'm gonna advise him, but he may.
All right, I'll hold it. Y'all go visit for a minute.
Yeah, we'll talk to him.
Have his attachments, so we can't close it until we get them.
That's
So
fine. I'll get that to you.
you have to have them today, otherwise I'm not going to be able to do this in the future.
Actually, I think I can send him by email, right?
Yeah, I mean, you can do it from your phone or your computer. That
Either
would
way, I
be,
have both of them here.
Yeah, if you can get that done before you leave, that'd be great, so
Yeah,
she can
I'll
close them
sit
out.
down. Yeah.
Okay, again, you're Evan Bowden, and will your client waive the formal reading of the indictment in each case?
You will, Your Honor.
Get to him. Mr. Bowden, in cause number 24, DCCR 0738, you're charged with the third-degree felony offense of evading arrest or detention with the use of a vehicle from March 6th of 2024, and how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily? And are you pleading guilty because you did what they charged you with? In cause number 24, DCCR 1660, you're charged also with the third-degree felony offense of evading arrest or detention with the use of a vehicle from June 16th of 2024, and how do you plead to that charge? Again, are you pleading guilty freely and voluntarily, and because you did what they charged you with? In each of those cases, I have here on the computer some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. West? Do you fully understand them? And do you understand, if I follow the agreements that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1 in each case.
No objection?
It's admitted in each case. Is there any evidence that Mr. Bowden is not competent?
No, Your Honor, not at all.
All right, sir, I'm going to find in each of your cases that you entered your pleas of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of those pleas. And cause number 24, DCCR 0738, find sufficient evidence to find you guilty, and at this time find you guilty of evading arrest or detention with the use of a vehicle. Sentence you in accordance with your agreement to a term of 2 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And cause number 24, DCCR 1660, also find sufficient evidence to find you guilty, and at this time find you guilty of evading arrest or detention with the use of a vehicle. Sentence you in accordance with your agreement to a term of 2 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These will run concurrently, which means together at the same time. In each of those cases, I'm handing you the trial court certifications that shows these were agreements that I followed, and so you've waived your right to appeal. I have also handed you written admonishments regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. West. Good luck to you, sir.
Your Honor, actually, can we put one more thing on the record just to cover myself? Can I have him, I guess he is sworn in, so Mr. Bowden, you understand you also have charges pending in Chambers County, correct? Okay. This could affect those, but we've decided it's in the best interest to go take care of these today, correct? Okay, you understand what's going on? And you're choosing to do this freely and voluntarily, like the judge said. That's all, Your Honor.
Thank you, sir. Good morning. You're Lawrence Jackson. And Mr. Rojas, will your client waive the formal reading of the indictment in each case?
He will, Your Honor.
All right, everything's taking a minute now, of course. Mr. Jackson, in cause number 24-1669, are we going on count one only?
Yes, Judge.
The state's elected to proceed on count one only. It alleges you committed the third-degree felony offense of driving while intoxicated, third or more, from May 6th of 2022. The indictment alleges you were previously convicted of driving while intoxicated March 2nd of 2012, and then June 28th of 2012, and then again July 28th of 2014. And how do you plead to that charge? You either did it or you didn't do it. Guilty or not guilty? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? Give me just a second to get to that second one. Sorry. And then in cause number 25-0189, you are charged. Let's count one in this one as well.
Yes, Judge.
The state's elected to proceed on count one only. And it alleges you committed the third-degree felony offense of driving while intoxicated, third or more, from April 18th of 2024. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with? In each of these cases, I have here on the computer some documents that have your signature on them that the state's marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Rojas? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? And it looks like the agreement is for 10 years in prison, and that would be probated, but there's not a number.
It should be 10 years.
10 years. Be probated for 10 years. You would be ordered to pay a $500 fine in each case, and also to enter and successfully complete the SafeP program. Is that your understanding? State tenders number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Mr. Jackson is not competent?
No, Your Honor.
All right, sir, in each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of those pleas, find sufficient evidence in each case to find you guilty. However, I'm going to reset your cases for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your cases, and then we will come back at a later time for sentencing. You can go back with the bailiff. Mr. Rivas, in cause number 25-0021, the state is elected to proceed on the lesser included offense of a Class A misdemeanor, attempted theft of a firearm, from October 18th of 2024. And how do you plead to that charge?
Guilty.
And are you pleading guilty freely and voluntarily?
Yes, ma'am.
And because you actually did what they charged you with? I have here on the computer some documents that have your signature on them that the state has marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, ma'am.
And are you a U.S. citizen?
Yes.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Rivas is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of that plea, find sufficient evidence to find you guilty, and at this time find you guilty of the Class A misdemeanor, attempted theft of a firearm, sentence you in accordance with your agreement to a term of 45 days in the Jefferson County Jail. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I have handed you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. All right, good luck to you, sir. You can go back with the bailiff.
Thank you, Judge.
Thank you. All right, sir, are you Dedrick Davis?
No.
And Mr. Parker, will your client waive the formal reading of the motion?
You will, Your Honor.
Mr. Davis, in cause number 24, DCCR 0344, I have a motion to revoke your community supervision. This shows that you were placed on probation May 14th of 2024 for the offense of theft of property with previous convictions, and that was a 2-year term in the state jail prison, and it was probated for 5 years. Is that correct? Answer out loud, yes or no. Thank you. It alleges that you violated your probation. Count 1 alleges that you failed to report as directed to the probation department April 4th and April 14th of 2025. And is that true or not true? True or not true? Count 2 alleges that you failed to work at, Count 2 alleges that you failed to provide verification of performing the community service hours as required. Is that true or not true? Count 3 alleges that you failed to enroll in services at the Spindletop Center as ordered. And is that true or not true?
That's true.
State will abandon count 4, no,
And 5 or not?
not 5.
Okay. Count 5 alleges that you failed to successfully complete the SAFE-P program. Is that true or not true?
It's true.
All right. Did you enter your pleas of true to counts 1, 2, 3, and 5 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state's marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Parker? And do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Davis is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent, or your plea is of true, freely and voluntarily. Find that you're mentally competent. Find counts 1, 2, 3, and 5 true. Find sufficient evidence to revoke your probation, and at this time, revoke your probation. Reassess your punishment in accordance with your agreement to a term of 12 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. You were handed, and I talked to you about the firearm, not being able to possess a firearm when you first got your probation, right? I've given you another copy of that. Make sure you read it and you understand the rules with regard to not being able to possess a firearm. All right? Good luck to you. You can go back with the bailiff. All right. Are you Alvin Lewis?
Yes, ma'am.
And will your client waive the formal reading of the motion in each case?
You will, Your Honor.
Which one are you doing?
3. I have both of them, or I can do the other one too.
I just clicked the other one. Don't worry about it. All right, so in cause number 19-32086, I have a motion to revoke your community supervision. Shows that you were placed on probation November 12th of 2019 for the third-degree felony offense of failure to register as a sex offender. That was a 10-year term that was probated for 10 years. Is that correct? And then in cause number 21-37343, I also have a motion to revoke, in this one, to revoke your unadjudicated probation. Shows that you were placed on probation June 21st of 2021 for the offense of evading arrest or detention with the use of a vehicle, and that was a 5-year deferred probation. Is that correct? Each of these motions allege that you violated your probation, and the state is going to abandon one, correct? Is that what you said?
No, Judge.
Oh, he was arrested for it. Okay.
Correct. I just wanted the court to know the case has not been brought to that.
Okay. Count 1 alleges that you were arrested for the offense of possession of drug paraphernalia on April 22nd of 2025, and is that true or not true?
True.
Count 2 in each case alleges that you possessed a drug, marijuana, on April 22nd, 2025, and is that true or not true?
True.
And then count 3 in each of your cases, or both of the cases, allege that you are behind in your court-assessed fees, and is that true or not true?
True.
Did you enter your pleas of true to counts 1, 2, and 3 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
Yes, ma'am.
In each of these cases, I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement is for me to continue your probations, but order that you enter and successfully complete the substance abuse track of the ISF program. Is that your understanding? So with regard to that evading, I think we're less than a year out. And so I think with that program, I'm inclined, if I'm going to go along with this, to extend that for a year or so.
Thank you.
Yeah, I mean, you're on 10 years for the other one anyway, but the evading, it was a 5-year probation. And I think based on what's been going on, I'm going to add a year to that, just so you can get through this program and the aftercare and all of that. Does that make sense?
Yes, ma'am.
Okay.
I don't know.
You can ask a question.
How many years do I have left on the 10-year?
Look, you're asking me to do math after my morning?
Oh, I'm sorry. I'm sorry.
The rest of it.
Yeah. So if you were put on in 2019 and you had 10 years, so that's 2029 for that case. Okay?
Yes, ma'am.
All right. Okay, so state tenders number 1 in each case?
No objection, Judge.
It's admitted in each case. Is there any evidence that Mr. Lewis is not competent?
No, Your Honor.
All right, Mr. Lewis, in both of your cases, I'm going to find that you entered your pleas of true to counts 1, 2, and 3 freely and voluntarily. Find those counts true. Find sufficient evidence in each case to find you guilty and revoke your probations, but I'm not going to do that. I'm going to follow the agreement that you made with the district attorney and continue your probation and order in each case that you enter and successfully complete the substance abuse track of the ISF program. In cause number 21-37343, I'm also going to extend that probation by 1 year as well. These were agreements. I'm going to hand you in each of your cases trial court certifications that shows you've waived any right to appeal. I hope you understand the opportunity that you're being given today. Take advantage of it. Do what you need to in ISF to get the tools so that you can be successful and not end up in prison. Because if you end up back here on another motion, that's very likely what will happen. All right, give me just a second. One of them's printing. I gotta get the other one.
Thank you.
Yes, sir. Good luck to you. Mr. Parker can bring those back in just a second if you want. Let me get the other one printed. Good morning. You're Lawrence Jackson. And Mr. Rojas, will your client waive the formal reading of the indictment in each case?
Here we are.
All right, everything's taking a minute now, of course. Mr. Jackson, in cause number 24-1669, are we going on count 1 only?
Yes, Judge.
The state's elected to proceed on count 1 only. It alleges you committed the 3rd-degree felony offense of driving while intoxicated, 3rd or more, for May 6th of 2022. The indictment alleges you were previously convicted of driving while intoxicated March 2nd of 2012. and then June 28th of 2012, and then again July 28th of 2014. And how do you plead to that charge? You either did it or you didn't do it. Guilty or not guilty? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they charged you with? Give me just a second to get to that second one. Sorry. And then in cause number 250189, you are charged, was count one in this one as well?
Yes, Judge.
The state's elected to proceed on count one only. And it alleges you committed the third-degree felony offense of driving while intoxicated, third or more, from April 18th of 2024. And how do you plead to that charge?
Yes.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with? In each of these cases, I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? And it looks like the agreement is for 10 years in prison, and that would be probated, but there's not a number.
It should be 10 years.
10 years. Be probated for 10 years. You would be ordered to pay a $500 fine in each case, and also to enter and successfully complete the safety program. Is that your understanding? State tenders number 1 in each case.
No objection.
It's admitted in each case. Is there any evidence that Mr. Jackson is not competent?
No, Your Honor.
All right, sir, in each of your cases, I'm going to find that you entered your pleas of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of those pleas, find sufficient evidence in each case to find you guilty. However, I'm going to reset your cases for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your cases, and then we will come back at a later time for sentencing. You can go back with the bailiff.
The courtroom shifts into a high-stakes plea hearing as the judge carefully reviews a defendant's extensive criminal history tied to a criminal mischief charge. Prosecutors outline multiple prior drug and burglary convictions, escalating the possible punishment range up to 20 years in prison. The defendant ultimately waives his right to a jury trial and enters an open guilty plea, leaving sentencing entirely in the judge's hands. Instead of imposing punishment immediately, the judge orders a pre-sentence investigation, signaling that the final sentence will depend on a deeper review of the defendant's background and history.